Good afternoon, morning, evening, wherever you are. Like, subscribe, share, scream. I want everybody to scream so I can hear you. I didn't hear you. Not legal advice, of course. I wanted to talk about a couple things today. I wanted to talk about MMTLP and my arbitration and why I took particular action. And I'm going to talk about GTII and the lockup period, about what we are doing or people are doing. Before I get into that, of course, I wanted to address three quick things. And you can guess out of these three, two are mine that I generated myself. One is an old standard. So I'll let you guess which ones are which as they go on. So how many FINRA arbitrators does it take to make a decision? None. Luckily, they are pre-made. Second one, never judge a book by its cover. This is obviously an old one. I was thinking about that. Use the paragraph on the back because that's the one that tells you what the book's about. And last but not least, and I guess you can guess who drafted this one, what's the difference between a FINRA arbitration and a colonoscopy? You can be sedated during a colonoscopy. I like that one, by the way. So I take pride in the last one. So I wanted to talk about those two things. First, I want to talk about MMTLP. So I got into MMTLP, the arbitration, for a couple of reasons, hopefully to get a positive result, but also to illustrate how the arbitration process has gone on. And we all have heard complaints about the FINRA arbitration system. We've heard it. As you could see, there have been very few arbitrations filed in the MMTLP matter, in any matter, by the way, involving customers. So, FINRA adjudicates disputes involving customers, and then they go after members. And we hear all those cases where they, fine Goldman Sachs, $500 for 600,000 mistakes they made allegedly 5 years earlier, which aren't disclosed. So those kind of the two different kinds of disputes they do. They do involving companies and involving retail traders or customers like us. So I decided, being involved in the MMTLP situation, to try and adjudicate, get in there. First of all, I filed a lawsuit. Lawsuit was kicked to arbitration. We went through arbitration. We started through arbitration. It was against Fidelity directly. So in the arbitration, I was trying to think how to put this in perspective. So I've participated in lots of arbitrations. By far, this is the worst arbitration ever that I've participated in. And I've had some where the results were reversed. So one thing you should know, and I'm going to do a video just about arbitration in the contracts that we have. But just so you know, if you go to arbitration, no matter what it is, and it has a contractual arbitration provision, you're kind of stuck with the result. So unless there's a colossal screw up, the court, who will basically validate the ruling of the arbiter, will require amazing facts to overturn it. I had a couple times where it was like that. But this particular arbitration was egregious. So during the arbitration, and there was three arbiters, one in particular, who happens to be, to a lot of these people who know what I'm talking about, the lead arbiter in this particular case was older than David Reichman, just to give you an idea. Anyway, if you look at your arbitration provision in your contract with your broker, it gives you some warnings. It warns you about discovery. It warns you about appeals. It warns you about being able to assert all claims. It may even have an exclusion for certain liability. Now, we sign it. It has an arbitration provision, generally no attorney's fees either. So if you tried to hire an attorney, you would have to pay that attorney or get it on a contingency. And the brokerages do it that way on purpose so that they will discourage people from filing actions. And you'd have to have a lot of money or be a lawyer who can do it themselves to do that. So does that provide a remedy? Not really. So during the arbitration, I was estimating 6 or 7 times to get rid of the main arbiter. And the reasons were varied, most of them because he decided matters without hearings, without rationale, without reviewing the claims, and without reviewing my paperwork on multiple times. For some reason, I found that to be disturbing. And when rulings happened against me, I was skeptical, let's say the least. And, I don't mind losing rulings. It happens in cases. You may not win all rulings and you may win some, but losing all of them is kind of unusual. And it's more unusual, and this was kind of what got me throughout, was I would ask for a document. Let's say, for example, so we're suing Fidelity over MMTLP. So maybe I ask, because I did, maybe I ask for Fidelity to produce all communications they had with FINRA and the SEC during the first week of December 2022. I would think that's a relevant time period because that's when the U3 halt took place. I also asked them, for example, to provide any correspondence or any information showing that Fidelity wouldn't sell MMTLP shares at any point in time 2022. I also asked for names of people, etc. So all those, and there's probably about 40 different requests, all of them turned down, motions filed, all the motions denied, no hearings, no rationale, whatever. When defendant, being Fidelity, asked, amazingly enough, the arbiter indicated we were required to turn over those documents. So it would be like if I asked for document, and I'm not crying sour grapes, because if you watch my history, you will see I've been complaining about this since the start, but literally, because it happened, if I asked for document X, the arbiter would say no. And literally, when Fidelity would ask for document X, the arbiter would say yes. So I found that disturbing. So filed a bunch of requests, half a dozen or more, to the extent it became a joke, trying to get rid of the arbiter. No luck there. Filed a bunch of motions to get discovery, including, by the way, and this is relevant, I tried to get the people involved in the FOIA response. So there was a FOIA response that reflected communications between the SEC and FINRA early December 2022, talking about investigations, etc. So not only did I try to get the documents or any documents related to that, I asked for the depositions of those people. So why did I ask for the depositions of those people? One, because I would be very interested in what they said. But two, we had a bunch of FOIA documents, but we don't know if those would be, okay, let me back up. So you're going into a trial or the same thing. You have documents you need to introduce. So how do you introduce them? Well, the other side could say, yes, you could introduce them. That wasn't the case in this particular matter. So to get them in, you actually have to provide some type of foundation for them. And they also must not be hearsay. In other words, like a document that's referring to something else, and you're asserting it for the truth of what the document says. So it can't be hearsay. It has to be an exception to get it in, because the other side's going to make an objection, hearsay. And then there also has to be somebody who could say, for example, if it's a document involving Sam Draddy and he's on the line and there's somebody else, Sam Draddy or somebody else is going to have to testify about that document. Otherwise, we wouldn't know what the context is. And if I had a witness, for example, who looked at the FOIA document that is exchanged between Sam Draddy and FINRA, and I ask the witness to tell me about it, it's going to be objected to. So this wasn't just formally discussed, but this is how I'm thinking when we get to trial. So I tried to get all the witnesses that would be able to establish the existence of these documents, what went on, etc. And they were all named in the FOIA reply. And the rules of FINRA in an arbitration, and again, in the contract, we're going to look at that contract at some point in time. The contract's going to say, warning, discovery is bad, no discovery. It's not like a normal lawsuit, but who really knows and who really reads that, to be honest, other than lawyers or somebody else, gluttons for punishment. But in terms of depositions, the rule is there have to be extraordinary circumstances. So, of course, I asserted extraordinary circumstances because it was a U3 halt, and it requires extraordinary circumstances. I made that motion to the arbiter, denied that one also. So, literally, every discovery request, every motion in seeking material information. So, to put this in context, if I was involved in a lawsuit and I had asked for all these things, all of them would have been provided. All the documents, the answers to interrogatories, and the depositions would have gone forward. In this case, even though the arbiter permitted Fidelity to have discovery, they prohibited me from having discovery. And I think in part it was a message, because in one of the filings that they had, they mentioned that they had watched our videos. They characterized it literally as hundreds of hours on MMTLP that I'd put out. That's a very interesting calculation. But I had, which means they had watched the videos, which means also that they knew I was going to talk about it. And I believe in part the reason that the way they conducted themselves was to communicate a message to us. And I believe that, that's not a proper tactic, but I believe that's what they were trying to do. So time goes on, and over the weekend, Memorial Day weekend, I had to prepare a whole bunch of documents to prepare for trial, which I did. I prepared a bunch of documents, submitted them. I think to date, before the dismissal, which was my choice, I had filed about 70 different documents in the arbitration. Prior to the arbitration, we were in federal court, and prior to that, we were in state court. So probably all told, probably 150 filings in these cases. So again, a normal person, I'm certainly not a normal person, but a normal person either just wouldn't do it. And certainly, unless you had a lot of extra dough to throw at this, there's no way you would do it, nor would I recommend that you do it at this point in time. So we got down to the point where we were getting ready for trial. I just had my witnesses lined up. But the problem is, because of not having those witnesses who could validate the documents, I knew that when the time came for trial, that a arbiter who had no interest in our position, who was clearly, in my opinion, in the bag for the financial industry, there was no way, if there was an objection to those documents, would he let it in. I also, at this point in time, knew that the result could not be positive, just the way they had been handling it. So I thought to myself, okay, whatever. Not a big fan of that either. But then it occurred to me, if I were the arbiter and I really wanted to screw retail, what would I do? What would be worse than finding against him? What would be worse is finding for me and for us, but giving a tiny damage figure. And, there's been discussion about, because there was the TradeStation lawsuit where it indicates or seeks damages approximately $40 to $50 a share, trebled for RICO damages based upon actual transactions. And I understood that, and that's not a limitation. None of these are limitations. But if, in fact, we went to arbitration, the judge, arbiter, who would be the central arbiter, because it'd be three, wanted to screw us, he would award us $2.90. That would then become an award that would be public. if it was taken up because it was in our favor, theoretically, unlikely that a federal court's going to unwind it, and unlikely on appeal that it could be unwound. So even though I was really invested in time, mostly time, some money, but mostly time in it, I didn't want to run the risk of getting some ridiculous number that somebody else, because it would be public, even though the proceedings are not public, the award would be. And I didn't want to take the risk. So notwithstanding whatever I said about the evidentiary issues, which would have been a problem, in the end, what put it over the top was I thought really that this particular arbiter, if he really wanted to screw us, would. And he's given me no indication otherwise throughout. It's been completely unfair. And again, he could set up a scenario where it would be really hard to get it undone. And if we get stuck with a $2.90 arbitration award, I can't imagine how that would be good for anybody. So as a result, after kind of thinking about all those things, I elected to dismiss the action. So it is dismissed. So I will not be pursuing that action at this time. Now, within that action, I may still have a battle with FINRA because there will be, and I think I mentioned this, at some point in time, I filed an action against the arbiter saying that I'm not going to be responsible for his fees. At some point in time, we're going to have an issue with FINRA about fees. And I believe I will be embroiled with them, involved about these fees, and will be able to disclose as a basis for arguing about the fees what went on in the arbitration. Not my favorite position to be in, but I do get another shot at them. On top of that, and I had mentioned this quite some time ago, somebody had talked me out of it. I do not know if I will be proceeding that way, but depending upon how the TradeStation case goes, I do not have a TradeStation account. So I'm not governed by the arbitration clause. So arbitration clauses only apply generally if you have a contract, and per the contract, you're obligated per the contract. I don't have TradeStation, so I have no arbitration clause. Now the theory is because they acknowledged that they sold more shares than they had, so they were short on some shares. And I know it's a small number, but they may not be the only ones. But in the grand scheme of things, if there's, and I'm just making up numbers, if there should have been 100 million shares, there was 100 million and 1,000 shares. That means the value of whatever I had, which I don't know what is whatever I had, was diluted, and TradeStation's responsible for that. So how much is the damages? I don't know. But what I've considered, because I considered it then, and I will consider it now, and if it's helpful, and because that's kind of the underlying thing, and the reason why I dismissed the arbitration is the whole idea is to be helpful and not create more problems, create less problems. I thought a $2.90 award, which was a possibility in light of the way the arbiter was acting, would create more problems. So I didn't want to do that. The TradeStation issue, it'll depend if it can provide some, because if I file an action against TradeStation, speaking out loud, besides dilution, obviously, it may provide an access for discovery. And that would be the very important part of that case. So I'm going to closely monitor the litigation involving TradeStation. If that's successful and they can avoid the arbitration issues, then I will stand back and see where it goes. And if that's a problem, then I will reconsider going after TradeStation as a non-TradeStation member, avoiding the arbitration clause, and moving forward. So those are the two things that I'm going to be focusing on besides whatever else comes out, because you could see this is kind of like a moving sidewalk. Things happen, we make decisions, and we react to it. Just like I did in the arbitration. At some point in time, there were certain things that changed, and I thought it was the best decision for everyone was the decision I made. So that's that. So what we have left over is the FINRA, whatever the FINRA part is, and the trade station, and whatever else comes out of that. So that's the MMTLP side, and I'm obviously following everything. And as new ideas come out, or as I think of new ideas, I'm happy to pursue them, obviously, and will. So second in the part, so that's the MMTLP side. Second part is the GTII side, which is funny to me. So somehow I got anointed as the GTII person. I checked out Alpine today, and there's still no decision in that. And I thought it could be. So there's an appeal, Alpine appeal in federal court, and there's an issue about a stay. It appears there's still a stay in effect because I haven't seen Alpine being banished, although I haven't seen the official stay ruling. And then there's the Alpine matter in DC about the expedited expulsion. The last brief submitted on that was March 31st. We're about 2 months into it. So that's enough time for the court to rule. However, there's a Supreme Court case that has still not been decided, Cherkesy, that we talked about, which is a case about the SEC's internal judicial system. And it might apply to entities like FINRA and SROs too. So it may be the case that the appellate court in DC is waiting to see what the Supreme Court ruling is. The Supreme Court ruling will be out sometime in June because that's when the last rulings come out. So I would expect the ruling about the expedited expulsion of Alpine to come out sometime in June now. That's what it appears to be. Could come out tomorrow or next day, whatever, but sometime in June. And recall, there will be a couple of additional appeals after that because Alpine can go internally and seek an appeal of the expedited expulsion proceeding, and then they can go to the Court of Appeal in the federal system and seek another review. And they could do the same thing in the action that was in Utah brought by the DTCC and the NSCC, where they're being expelled from that system. But they have routes in both cases. Now, again, that's not indefinite. It'll end at some point in time. Again, they'll get the death penalty, but we're not there yet. And again, I've tried to keep everybody apprised of that. So as a result of that, I got involved, and after hearing from everybody, I got involved in trying to get a group together to get rid of existing management, because I thought that would be beneficial to everybody. And in fact, the position of the attorneys for GTII, they have not really been super responsive and not super helpful. But anyway, so in GTII, I wanted to get a group together to get rid of management. So I've been out there. I've spoken to the existing council. They did reiterate that it was beneficial to all shareholders if they did a deal. They, as you know, because I talked about it in real time, they talked about ongoing transactions, making moves to that. They talked about filing documents on a timely basis. Anyway, I've outlined that, and it's complete inability, in my opinion, to satisfy all those. So I started to get a group together, and we were trying to keep this quiet because we didn't want the management of GTII to prepare for that. At some point in time, after there was so much discussion, it became less quiet, and people started asking questions. So I decided, even though it's not I would prefer this being done quietly. I'm going to answer the question so people can have an understanding of what they're getting into if they are going to get into it. So the way I would explain it is like this. And, you'll get them if you reach out, I will put you in contact with somebody who will give you a greater explanation. And the person who will be actually doing the legal work is not me. To the extent we go forward, and that's the way it looks like we are at this point in time, I will be a point person and kind of be able to describe what's going on, but I won't be the one who's appearing in court, etc. I've provided information and provided help, but I'm not the one who's going to do that. So what happens And what we discussed amongst various reasons is we need somebody else to replace management, certainly on a day-to-day basis, and then bigger than that. So is there a process to do that? Yeah, there is a process to do that based upon certain factual circumstances. And, I've talked about all the nonsense that's gone on here. So I think factually, there's a decent chance that we will be successful. Decent, I'm being conservative. And obviously, this is not legal advice, especially since I'm not the one drafting it, but it's my opinion based upon what I know, but not legal advice. So to get new management in, you'd have to go into a court. And so there's a process, there's various processes by which you can go into court. And to do that, and people have guessed this and people have cited this, you need approximately 10% of the shares that are outstanding. Now, I don't know if they have to be legitimate shares, because does that include counterfeit shares? Does that include shares that were improperly issued? I don't know. But in our analysis, we've just taken the gross number of shares, which is about 380 million, as the number. And it requires, whatever we're going to do, 10%. So that's about 38 million shares. Now, remember, in 2023, there was dilution of about 110 million shares. And if, just so we're clear, we're not far off the number we need. And if the number reflected what the share concentration was in 2022, we already have sufficient number of shares for that. So that dilution raised the number, even though the dilution appears to be putting shares in their own pocket. But it is what it is. So it requires a certain percentage of the shares, and people have already talked about it openly. So 10%. So we're at 38 million. And I think I estimated we were about 80% of the way. And I think, and there's obviously people still reaching out, happened today, still ongoing. So I'm not, no guarantees, but we're working our way towards the amount. So then there's discussion about a lockup period. This is not kind of like the lockup period where you, like it's an IPO and you're an insider and you can't sell, like DJT, for example. Trump has that stock and shares, but he can't sell it for 6 months. And there might be a restriction, actual physical restriction that's on the stock. So it's not that type of thing. But under the particular section that we would be going under, it says that while you're seeking to appoint the person to take over the business, not the entire case, but just the part about removing day-to-day management, that you need 10% of the shares, and those 10%, they can't sell during that period of time. So I'm aware of that. And I thought to myself, how long is that period? And I know that the person who provides the time frame is giving the period that is the most conservative period. So I think what the reference is, it could happen, from a day to 6 months, anywhere in that. And again, not legal advice, but I've been involved in similar proceedings in California, involving the appointment of similar people in similar roles. And I don't recall a time in my experience where it took more than 90 days. Most times substantially less. And once that stage is completed, it appears that any lockup, and that lockup would be informal. There's no restriction on the stock. I don't know, by the way, what would happen if someone who says that they locked up their shares unlocked them. It would probably depend, one, whether there were more than 38 million shares and those shares were even needed, and two, if it was found out. But for the sake of our discussion, we're going to say that you have to stick with it. So in my mind, from the time, and also the request, whatever the relief is sought to bring in somebody else to run the business, my guess is that will happen right at the start of the case. And so the clock will be running. And so to the extent that you participate, and I hope everybody participates, because I believe, in my opinion, getting rid of management is the only way to get this on the right tracks. Anybody who participates will have a informal lockup until the process whereby this person is either put in or not put in. And again, my experience, I've never seen it last more than 90 days, but I know that the time frame that's been provided is 1 day to 6 months. And I believe, again, that's being conservative. So if you come in, there is a soft lockup. We would participate, we would appreciate everybody's participation, but I understand people might have be reluctant in some fashion, even though I don't think, and again, it's just my opinion, I don't think it's likely that there's going to be any substantial run-up. And in the meantime, as the directors sell off shares and may sell off more shares, and since there's nothing going on with the company per its own 10K and per firing the auditor that was the scam auditor, for being downlisted, it's all public. Everybody knows, and everybody's been in contact knows about them. So I find it hard to believe that anybody's going to have any particular interest in them in the meantime. So, but if you're not willing or interested in participating, I understand that. I don't agree with the argument about a squeeze, because this rate, again, might be a squeeze from 3 cents to 9 cents. Not financial advice, but I believe it's really that when management goes, when there will be any type of real move. And I'm not the only one who says that. And last but not least, I think people are under the misconception, maybe not, I don't know if they're under the misconception, but I think they are. Let's say you had 10 million shares of GTII. You don't have to pledge all 10 million. If you're some large shareholder, or if you're a small shareholder, and you're not otherwise want to participate in this, if you want to participate by having some of your shares involved, you could do that too. So if you happen to have, I think maybe somebody like Busy Brands, if he has 10 million shares, perhaps he only puts up 5 million. And you can do that as far as I know. So kind of the recap about GTII. There is a soft lockup. The lockup only, per the statute, the lockup only applies to the time period in which the person who would take over the operations of the business during that appointment time. Once that person is appointed, or once they're not appointed, either way, that lockup, the informal lockup, would appear to cease. At least that's what the statute appears to suggest. So would love to have you pop on board. If you could, reach out to Teslaw, TESSLAW 420 at gmail.com if you have interest, and I will provide you additional information. So let me recap as I do, and then I'll see if there's any questions that I could read, again, because I only see out of my left eye. With MMTLP, because of the risk of how proceedings were going and the risk of getting an award that would be used and contrary to our interest, elected to dismiss that particular arbitration, and considering pursuing TradeStation, and expect to have another battle with FINRA shortly with regard to that. And secondarily, as to GTII, anybody who wants to get on board, please reach out. And if you're not so inclined, then so be it. That's fine. You could do it. Do what makes you comfortable. But remember, you also have the option to pledge only a portion of your shares as the whole amount if you have concerns about whatever the lockup period appears to be. So that's my brief summary. I wanted to bring everybody up to date about the MMTLP situation, because that's just happened. And I wanted to bring everybody up to date about GTII, because I've seen that question being raised about the informal lockup. I hope that clarifies the position. And anybody, by the way, who responds and has questions, I think I've responded to everybody. I think on the one email site, excluding other contacts, because I kept on referencing how many people had reached out. On the email site, I think I'm close to 500 alone, besides other contacts I've gotten. So the question is, what happens? That was the answer. So if a short squeeze happened while your shares were locked up, technically speaking, you're not supposed to sell your shares. That's the answer to your question. So you'd have to believe that a short squeeze would happen without doing anything, because that's what you're going to have to believe, or you're going to have to believe in whatever time it takes for Alpine to do something. If in fact that's going to work, that's going to happen. I just don't believe that. I believe there may be a short squeeze at some point in time, but knowing enough about these companies and the people that are involved and the people that have interest in them, I just don't see it. But that's just my opinion, and everybody should do what they're comfortable to do. Like I said, we're about 80%, at least when I put that up, we were about 80% home. We could be more than that. You know, anybody who wants to join, everybody is welcome. There's nobody who's going to be discouraged. There is no cost or obligation or fee to anyone. I certainly do not get paid out of it, not my interest. And that's it. So if there's any other questions, I'm just taking a quick look at that. Malcolm Gilchrist, TESSLAW420 @gmail.com. Anybody else have any questions? If not, I will place this on. It'll be up as a video. If when you look at it on a video, if you have further questions about either the MMTLP or the GTII side, I am really happy to answer it. And that's it. So hopefully everybody knows. If you have questions, reach out. Everybody be well. Take care. Have a great day. Talk to you soon. And goodbye.